Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Shreerang Agashe. Advocate Shreerang graduated BA and LLB in the year 2023 from NBT Law College, Nashik. He also holds a diploma in cyber law from Savitribai Phule, Pune University. Today, Advocate Shreerang is going to speak on the Digital Personal Data Protection Act 2023. So without wasting further time, I would request Advocate Shreerang to commence with his lecture. Thank you.
Hello everyone, so my topic is the Digital Personal Data Protection Act 2023. It is a landmark legislation aimed at regulating the processing of digital personal data while safeguarding individuals' privacy. This act aligns with global data protection standards and ensure accountability among entities handling personal data. So nowadays we know that data has become everything. Like in every aspect, in every industry, there is a data. Doesn't matter if it is regarding money, doesn't matter if it is regarding the entries, doesn't matter if it is regarding any subjective thing to that industry. But data is the most important thing nowadays. Now it is said that data is often referred as new oil because the way oil industry has influenced the economy, influenced the market, multiple industries. In the same manner, data is influencing all the industries and the economies of multiple nations. So nowadays the importance of data has grown, and we really need to administrate it properly, and we really need to work on it, how to process the data, how to govern it, how to locate it, and how to control it. So it is the most important part is controlling the data, and to control we need a legislature. To control the data we need a perfect and accurate law for that, and for that purpose the Digital Personal Data Protection Act 2023 has incorporated in law. For that purpose it is incorporated. So as I said, the data is new oil. So as now we know that our choices, our consumer behavior, even the political opinions, all these things are influenced by the data. See, if you can see in your daily life, if you continuously talk about a bicycle in front of all your digital devices, if you keep talking about it for at least 3 minutes, you will get starting advertising of bicycles, different companies. And this is how there is one saying, as Zuckerberg is listening, that is the part how our data is leaked and how there is no control on any governing bodies or any fiduciary bodies. So we really need to control it, and for that purpose this act has been incorporated. Now what happened in 2017, a retired Karnataka High Court judge, Justice Puttuswamy, K.S. Puttuswamy, challenged the Aadhaar scheme in Supreme Court. And what Supreme Court observed, what Supreme Court directed, that the right to privacy is a fundamental right under Article 21 of the Indian Constitution. It is a most important landmark judgment in recent years. So you really need to go through it to understand why the Digital Personal Data Protection Act was incorporated. Now what happened after this case? The government, 2018 government, formed a committee under Justice B.N. Srikrishna to draft a data protection framework. And in 2019, this committee introduced a draft to Parliament as a personal data protection bill, which undergone 80 amendments. So it was very difficult for the committee to incorporate all these 80 amendments in it. So after that, what happened in 2023? They actually had to amend and change the whole draft introduced in 2018. So in 2023, they came up with the bill which was passed as the Digital Personal Data Protection Act 2023, and it was revised, and not all the 80 amendments were taken into the consideration, but most of around 80% amendments were taken into the consideration in this new draft. So there are also some exceptions and there are also some loopholes to this act. If we consider the leftover 20% amendments which were suggested by the parliament, which we will see it in the upcoming session. So the topic is the Digital Personal Data Protection Act. Now, to understand this act, we need to understand what is data and what is personal data. We need to understand the types of data, as what is the difference between data and personal data. So personal data are piece of information that relate to an individual person. It is often used for understanding preferences of individuals, which may be useful for customization, targeted advertising, which I referred earlier, and developing recommendations. So as per the data, the companies develop their strategies to market you, to target you on the grounds of data. This level of importance is there in this world today about data. So earlier there was no standalone law for personal data protection. Use of personal data protection was regulated under the ITC Act, Information Technology Act 2000. In 2017 case, Puttuswamy sir pointed out the flaws and the importance of protection for personal data. So now understanding what are the main objectives of this act. So the said bill seeks to provide for protection of digital personal data. We will go for the perfect definition in section 2 of this act, where all the words, all the terminologies are explained. The second thing is to lay down grounds for processing the personal data. So here comes first protection, second processing. Third, to place general and in certain case special obligations on entities that process personal data. So in this act we will also understand which entities process the data, and we really have no idea which entities actually process our data, because many of the times we never focus on what permission, what consents we are giving to different apps on a digital platforms. So now talking about data, so there are different types of data: digital data, personal data, non-personal data, critical data. So what is digital data? Any information stored or processed in digital form. What is personal data? Any data that relates to an identifiable individual. So the data, for example, Aadhaar, on the grounds where Puttuswamy sir pointed out to the Supreme Court by challenging Aadhaar scheme, that's how this importance of personal data was raised. What is non-personal data? Data that cannot identify a person. So data which cannot identify a person, but it is a digital data. What is critical data? So critical data is sensitive data that, if compromised, could affect national security. Like for example, the status of army, the equipments of the accounts of army, the equipments of army. Also there are multiple terminologies which will be used in this act, which are explained in section 2. Some terminologies which are very important, I'll point it out: data principle, data fiduciary, data sovereignty, and data localization. So now coming back to the bare act, in section 2 we can see the definitions. So there are multiple words which we really need to understand this act, to learn this act. And when I was in college, I want to quote my one of the professor who used to say that law is just all about your logical thinking. So if you understand all the terminologies and put your logic behind it, you will understand the whole law. So this section 2 is very important and crucial part of this act. If you understand all the terminologies, then it will be very easy for you to understand and learn this act. So there are different words like automated, board, certain legitimate uses, chairperson, consent manager. So now according to the act, what is data? Data means a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation or processing by human beings or by automated means. This is data. So this is a general definition of data, and now there are multiple categories. One of it is personal data, on which the act is based on. So what is personal data? Personal data means any data about an individual who is identifiable by or in relation to such data. So personal data, for example, what is personal data? Our Aadhaar card, our PAN card number, our rationing card and our passport, all these things describes us and gives information about an individual. So that is why it is known as personal data. And most of the times on many websites and for many apps, we submit all these documents and there is no understanding of protection of our personal data. There is one more terminology, data fiduciary. What is data fiduciary? Data fiduciary means any person who alone or in conjunction with other persons determine the purpose and means of processing of personal data. So data fiduciary is just like the companies like Meta, like Instagram, Facebook, on which you have your accounts and you have provided most of your information on it. So that is data fiduciary. What is data principal? So data principal means the individual to whom the personal data relates, that is us. So we are data principals. So the data principal is explained, a child includes the parents or lawful guardian of such a child, or a person with disability includes her lawful guardian acting on her behalf. Now who is data processor? Data processor means any person who processes personal data on behalf of the data fiduciary. That is data processor. For example, the data fiduciary is the Meta company, and who process the data? The Instagram, Facebook, these are the companies which process the data, and according to that they develop their algorithms. Data protection officer means an individual appointed by the significant data fiduciary. So the persons in those companies who are appointed to process all the data are data processors. There is also one terminology, personal data breach, which means any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destructions or loss of access to personal data that comprise the confidentiality, integrity or availability of personal data. So what is personal data breach is explained in this definition. So breach is like usual breach of contract. So we know how the contract is breached. In the same manner, when your personal data is misused, it is also considered as breach of personal data. Now what is processing? Processing the data. So in relation to personal data, processing means a wholly or partly automated operation or set of operations performed on digital personal data and includes operations such as collections, recording, organization, structuring, storage, etc., etc. There are multiple things where we use our personal data. Now I really want to point out one part here, that she, SHE, is relation to an individual includes the reference to such individual irrespective of gender. So in the whole act, when she is used, it is for the individual to whom the personal data is related to. Now in section 3, there is application of act. How we can apply this act? Now first, we will understand this act chapter wise. So the first chapter, which is preliminary, where short title, commencement, definitions and application of act is given, like section 1 to 3. In chapter 2, obligations of data fiduciary, from section 4 to 10. In chapter 3, rights and duties of data principal is given. All the rights like right to access information about personal data, etc. All these things are given from section 11 to 15. In chapter 4, special provisions of this act about personal data is given in section 16 and 17. In chapter 5, Data Protection Board of India. So this act forms a board, Data Protection Board of India, and all about this board, like who can be part of this board, who can be a chairperson of this board, how a person can resign, etc. All the things about that board is given in chapter 5 from section 18 to section 26, including the powers of chairperson, powers of members, powers of this board, and also the jurisdiction of this board. Chapter 6, powers, functions and procedures to be followed by the board. So the powers and functions which are governed and followed by the board are given in section 27 and 28. Chapter 7, appeals and alternate dispute resolution, ADR. So all about appeals and ADR methods. The information and the connection regarding this act is given in chapter 7 from section 29 to 32. And in chapter 8, penalties and adjudication. So what will be the penalties? What will be the adjudication of this act is given in section 33 and 34. And there is one more chapter, which is chapter 9, which gives all other miscellaneous part of this act, which cannot be quoted under any frame. So I'll give some example as in some topics from this miscellaneous. Protection of actions taken in good faith. Power to call for information. Who has powers to call an information? So earlier I said ki 20% of part was not incorporated, 20% of amendments. In this act, the majority of the power is given to the central government. So the powers which government wanted more. There is also bar of jurisdictions, power to make rules, powers to amend the schedule and amendments to certain acts. So this is given in miscellaneous part, which is chapter 9 of this act. So it is very tiny bare act and around 28 pages of act. So it is very easy. As I said, if you understand the section 2, all the terminologies, it will be very easy to understand this act. There is nothing different and difficult to understand in this act. Now I would like to come back to the point, which is application of act, which belongs to first part of this act. So this act apply to the processing of digital personal data within the territory of India, where the personal data is collected in in digital form or in non-digital form, and second part in non-digital form and digitalized subsequently. In today's world, we register a document and then we scan it and then we make a digital copy of it. So it is known as digitized data. So part B, section 3B, which says this act shall also apply to processing of digital personal data outside the territory of India if such processing is in connection with any activity related to offering of goods or services to data principals within the territory of India. So for example, the way Amazon works, Amazon take all the permissions of our phone, of our personal data from us. We allow and provide all our personal information to Amazon. Then we order some product, and the act says if we order something and then we revoke the consent of the personal data which we have provided, then Amazon shall not withheld the product which we have ordered earlier when the consent was given. So to govern this act is applicable on these part of transaction as well. Now this act shall not apply to 1. Personal data processed by an individual for any personal or domestic purpose. Second, personal data that is made or caused to be made publicly available by 1. The data principal to whom such personal data relates, or any other person who is under an obligation under any law for the time being in force in India to make such personal data publicly available. So when we give a consent to make our personal data be available publicly, then this act shall not be applicable to such cases. For example, we usually have an open account, like public account on Instagram or on Facebook, and if we share any personal data on it, if we share the photo of Aadhaar card, and if someone misuses it, then this act will not be applicable to that. But there are some provisions by which we can protect ourselves and prohibit that person from misusing our Aadhaar card. Chapter 2 of this act, obligations of data fiduciary. So we have understood, again I would like to mention what is data fiduciary. So data fiduciary means any person who alone or in conjunction with other persons determines the purpose and means of processing of personal data. That is data fiduciary. Now, what are the obligations of these data fiduciaries? First, section 4 says grounds for processing personal data. 4.1. A person may process the personal data of a data principal, which is us, consumers, or we can say an individual. Personal data of a data principal only in accordance with the provisions of this act for a lawful purpose, which is A, for which the data principal has given her consent. B, for certain legitimate uses. And second part of this section says, for the purpose of this section, the expression which is lawful purpose means any purpose which is not expressly forbidden by the law. That these are the grounds where a data can be a personal data. Again, I would like to mention in the whole lecture I am mentioning data is personal data. So the data the data processed by the data fiduciaries on these grounds. Section 5 says notice. So every request made to a data principal under section 6 for the consent, section 6 is consent. So every request made to a data principal under section 6 for consent shall be accompanied or preceded by a notice given by the data fiduciary to the data principal, informing her A, the personal data and the purpose for which the same is proposed to be processed. So if we go through all the apps, all the digital softwares, all the digital websites, whenever we say yes, we have read all the terms and conditions and all the consents we are giving. If we go through it thoroughly, we will understand all these points are there or not. We really need to learn and we really need to read all those documents for which you are giving consent to your access to your personal data. The manner in which she may exercise her rights under subsection 4 of section 6 and section 13. So 6 is consent and 4 is grounds. So why these fiduciaries are using your data is what should be mentioned in the notice, is what should be mentioned while giving all the consents. So section 5b says, section 5.2.b says, the data fiduciary may continue to process the personal data until and unless the data principal withdraws her consent. The data fiduciary has rights over your personal data until you do not provoke your consent. So there is one example, X, an individual gave her consent to the processing of her personal data for an online shopping app or website operated by Y, an e-commerce service provider, before the commencement of this act. So before the commencement of this act, the consent was given by X to Y. Upon commencement of the act, Y shall, as soon as practicable, give through email, in-app notification or other effective methods information to X, describing the personal data and the purpose of its processing. So if you have given the consent before the commencement of this act, then you should notify to all those data fiduciaries that in-app notification or other effective method information to X, which is to the data fiduciaries, describing the personal data and the purpose of its processing. The data fiduciary shall give the data principal, which is us, the option to access the content of the notice referred to in subsection 1 and 2 in English or in any language specified in the 8th schedule of the Constitution. Now coming to the consent part, which is section 6 of this act in chapter 2, the consent given by the data principal shall be free, specific, informed, unconditional and unambiguous, with a clear affirmative action, and shall signify an agreement to the processing of her personal data for the specified purpose, and be limited to such personal data as is necessary for such specific purpose. So the consent should be very specific and informative. Now here is one example again. X, an individual, downloads Y, a telemedicine app, an app on which you can order your medicines. Y is that app, Y requests the consent of X, which is the user, for the processing of her personal data for making available telemedicine services. So what Y does? Y asks the personal data to allow X to use Y's application. Second, accessing her mobile phone contact list, and X signifies her consent to both. So what we usually do whenever we install a new app or a new software, we consent to all, like we don't even read it. That negligence is not suggested, as in we really need to learn and read all the points given in that part. So she signs and gives consent to the both. Since phone contact list is not necessary for making available telemedicine services, her consent shall be limited to the processing of her personal data for making available telemedicine services. Now here comes the part. There are multiple apps which we use just for the sake of booking cab, for the sake of booking or ordering some stationery, and we give permission to all of our contacts, our camera, our microphone. So to restrict the use of personal data collected through these consents is restricted here in consent. So the consent, we really need to go through it, and it is said that consent should be specific, that consent should be specific about the data to process it. So her consent shall be limited to the processing of her personal data for making available telemedicine services. So the permission which was given by her, it should be subjected to the intention of that Y's app. There is also 1.4 at number 4, where consent given by the data principal is the basis of processing of personal data. Such data principal shall have the right to withdraw her consent at any time. So we should always have a right to withdraw the permissions which were given to all the apps and all the data fiduciaries. I would like to suggest you to check your settings in your phone and to withdraw unnecessary consents which were given by you to unnecessary apps. So there is also one more example. X, an individual, is the user of an online shopping app or a website just like Amazon and Flipkart, which is Y, an e-commerce service provider. X consents to the processing of her personal data by Y for the purpose of fulfilling her supply order and place an order for supply of a good while making payment for the same. So X gives all the required consents. Now if X withdraws her consent, Y may stop enabling X to use the app or website for placing orders, but may not stop the processing for supply of the goods which were already ordered and paid by the X. So as I earlier said, if we order something on Amazon and if we delete the app and if we withdraw all the consents given to that app, then that company should not withheld and restrict our previous order which was given when the consent was given. So there is 6th point which elaborates this example. If a data principal withdraw her consent to the processing of personal data under subsection 5, the data fiduciary shall within a reasonable time case and cause its data processor to cease processing the personal data of such data principal unless such processing without her consent is required or authorized under the provisions of this act or the rule made thereunder or any other law for the time being in force in India. So the point number 6 of section 6 clearly explains this example. Now section 7 says certain legitimate use. So the use of data. A data fiduciary may process personal data of a data principal for any reason, like for the specified purpose for which the data principal has voluntarily provided her personal data to the data fiduciary and in respect of which she has not indicated to the data fiduciary that she does not consent to the use of her personal data. For the state or any of its instrumentalities to provide or issue to the data principal such subsidy, benefit, services, certificate, license or permit as may be prescribed where she has previously consented to the processing of her personal data by the state or any of its instrumentalities for any subsidy, benefits, services, certificate, licenses or permit. So now there is one example. X, an individual makes a purchase at Y, a pharmacy. She voluntarily provides Y her personal data and requests Y to acknowledge receipt of the payment made for the purchase by sending a message to her mobile phone. Y may process the personal data of X for the purpose of sending the receipt. So there is some certain legitimate uses which are given in this section 7. Section 8, general obligations of data fiduciary. A data fiduciary, so there should be some obligations on these data fiduciary. So a data fiduciary shall, irrespective of any agreement to the contrary or failure of data principal to carry out the duties provided under this act, be responsible for complying with the provisions of this act and the rules made thereunder in respect of any processing undertaken by it or on its behalf by a data processor. Second thing is, a data fiduciary may engage, appoint, use or otherwise involve a data processor to process personal data on its behalf for any activity related to offering of goods or services to data principal only under some valid contracts. Where personal data processed by a data fiduciary is likely to be 1. Used to make decision that affects the data principal or disclosed to another data fiduciary. The data fiduciary processing such personal data shall ensure its completeness, accuracy and consistency. So there is one more example about general obligations of data fiduciaries, which is X. An individual registers herself on an online marketplace operated by Y, an e-commerce service provider. X gives her consent to Y for the processing of her personal data for selling her used car, the online marketplace helps conclude the sale. Y shall no longer retain her personal data. So we usually tend to give our car to such websites which sell second-hand cars, and we give all our personal information including our RC book, all the details of that car and our personal information. So after the execution of deal is done, that company, that website shall not use our personal data for any reason. These are some basic general obligations of data fiduciary. Again, as my professor used to say, that law is all about your logical thinking. So if you understand all the terminologies like data fiduciary, data principle, you will understand this act by using your logical thinking. So section 9 is processing of personal data of children. So what it is very logical thing, if a person is below 18, as the person is minor or an unsound mind, then there should be a parental control on that person. There should be consent taken by their parent, their respective parent, is given in section 9. Chapter 3, rights and duties of data principle. So in chapter 3 there is section 11 to section 15. Section 11 says right to access information about personal data. So some rights are given, rights and duties are given of data principle, which is us, to whom the data belongs to, are given in this chapter. Right to correction and ensure personal data, right of grievance redressal, duties of data principle, all these things are given in chapter 3. Chapter 4, there are special provisions. So processing of personal data outside India, such kind of special provisions like exemptions to all such kind of examples and such kind of scenarios are given in this chapter. Chapter 5 is all about Data Protection Board of India. As I previously explained, chapter 4 is all about the board. The board which was formed under this act, which is Data Protection Board of India, is given in chapter 5, like establishment of board, composition and qualification for appointment of chairperson and members, disqualification, resignation, salary allowance, etc. All these things are given in this chapter 5. Chapter 6 says powers and functions and procedure to be followed by this board. So powers are given, powers and functions or the duties of this board is given in chapter 6. Now chapter 7 is all about appeal and alternate dispute resolution, which is ADR. Chapter 8, which is penalties and adjudication, and chapter 9, which is miscellaneous. So chapter 9 is also one of the important chapter in this act, where the protection of action taken in good faith, power to call for information, like central government has power to call upon your personal data information, like that. All these powers are given, and how it is governed is given in under this act. Power of central government to issue directions, consistency with other laws, bar of jurisdiction, power to make rules, lying of rules under certain notifications, power to amend schedule, power to remove difficulties, amendments to certain acts. These things are given in miscellaneous. So that's all. The Digital Personal Data Protection Act is not very difficult act to understand and to learn, but it is the most important act to secure your personal data. Thank you so much.
Shreerang, thank you very much. It was a nice overview of the Personal Data Act 2023, and this is, I think, one of the most needed act, because as on today, whatever little shoppings from Zepto to Zomato to Flipkart to
Amazon,
booking of your rail tickets, everywhere this is concerned. So I think this was a very relevant and apt topic which we have discussed. So thank you very much for that, and a small token from Hammurabi to you.
Thank you so much. Thank you so much for giving me this opportunity, sir.